Well, welcome everyone, and thank you for joining us virtually this morning for what we hope will be an informative presentation for tenants in the city of Richmond. My name is Paige Rusa, and I am the Deputy Director for the Rent Program. And this morning, Palomar Sanchez will be conducting the presentation. Before we get started, I wanted to share some logistical information. Please note that this presentation has been posted on the website at www.richmondrent.org/workshops. So you can access a PDF copy of the workshop there. Please also note that this presentation is being recorded, and we hope to post the recording on our workshop page as well. So if you want to come back and review the recording again, you're able to do so. If you have questions on a particular topic today, we ask that you type your questions into the Q&A box at the bottom of your screen, and we will address your questions at the end of the presentation. So without further delay, I want to pass it off to Palomar Sanchez.
Thank you, Paige. Good morning, everybody, and welcome to the How to File a Rent Decrease Petition presentation. Hopefully, this will provide some useful information for anybody who is considering filing a petition, as well as for anyone who just wants to get educated on this process. So thank you for joining us, and here we go. All right. So first of all, we just want to give a quick update. The Director of Emergency Services issued an order, Resolution 2020, effective March 17, 2020, during the period of local emergency in response to COVID-19. Further, on July 14, 2020, the city manager in her role as Director of Emergency Services passed a fourth supplemental order, Resolution 7420, which states that no landlord may terminate a residential or commercial tenancy for 1, non-payment of rent, and there is a qualification that the tenant must notify the landlord of their financial hardship in writing, and then, or they cannot terminate for any no-fault just cause for eviction, such as owner move-in, withdrawal from the rental market, substantial repairs, or temporary tenancy. This order has been extended until September 30th, 2020, which is very soon. The order also prohibits any residential rent increases for any rent-controlled property. Exceptions to the rent increase prohibition include properties such as single-family homes, condominiums, new construction, which is anything built after February of 1995, and any other property whose rent cannot be regulated pursuant to state or federal law. Landlords may also not charge late fees or require documentation to prove financial hardship. For the most up-to-date information, please see our website at www.richmondrent.org. And by the way, we are aware of the new state law, and so please check in with us next week, which hopefully by then we will have some more information about the newly passed state law and how it may affect Richmond residents. All right. Excuse me. So some of the topics covered today are right here. We're going to do the overview of the Richmond Rent Ordinance, talk about, the purpose of the Rent Ordinance, overview of the ordinance, properties covered under the Rent Ordinance, discuss petitions due to excess rent, petitions due to reduction in space or services and habitability issues, and then petitions due to a landlord's failure to pay relocation payments. Included in all this is kind of just a basic learning how to file, and also the overview of the entire process from start to finish. All right, so the purpose of the Rent Ordinance. The purpose of the Richmond Fair Rent, Just Cause for Eviction, and Homeowner Protection Ordinance, also known as the Rent Ordinance, is to promote neighborhood and community stability, healthy housing, and affordability for renters in the city of Richmond by controlling excessive rent increases and arbitrary eviction to the greatest extent allowable under California law, while also ensuring landlords fair return. All right, so here's a brief overview of the Richmond Rent Ordinance. I'm going to get to that. Okay, there we go. So as in most rent control jurisdictions, they're broken up into basically two major pillars. One is going to be rent control or rent regulation, and the other is going to be just cause for eviction protection. So let's talk about rent control first. So the rents are regulated. And again, these are specifically for rent-controlled units, and there are some exceptions to that, but we can discuss that in a bit. So for rents that are regulated, the maximum allowable rent is calculated by taking the base rent and then adding annual general adjustments, which is the cost of living increase, and also any allowable individual rent adjustments that is ordered by a hearing examiner when there is a petition filed. So if you split that into two categories, the two major categories, you look at the annual general adjustment and the petition process. That's really the two ways to increase the rent on a rent-controlled unit. So the annual general adjustment, otherwise known as the AGA, is 100% of the consumer price index in the Bay Area, which is otherwise known as the inflation rate. And then there's the petition process. So the petition process is a mechanism to increase or decrease the MAR, which is the maximum allowable rent, based on reasons permitted by the rent ordinance. And by the way, the base rent is going to be one of two things. One, it could be the rent in effect as of July 21st, 2015, and those are for tenancies that were in existence prior to that date, or the first rent charge for tenants that moved in after that date. So if someone moved in after this date and they had a brand new rent, that's the base rent. However, if they were in the unit prior to this date, and then at some point their rent was either kept the same or increased, whatever it was, we look at what the rent was for that date, and that's what we use as a base rent. Okay. So next is the just cause for eviction protection. So part of the ordinance requires or says, mandates that a landlord needs to have at least one of the 8 just causes to terminate a tenancy. There is no other way to terminate a tenancy for any tenants that can avail themselves of these protections. So the first one is failure to pay rent, most basic. Number 2 is breach of lease. Number 3 is nuisance, which is sort of a catch-all. 4 is failure to give access when the landlord had a right to do so. 5 is to temporarily vacate in order to undertake substantial repairs. 6 is owner move-in or owner relative move-in. 7 is withdrawal from the rental market, which is otherwise known as the Ellis Act. And 8 is a temporary tenancy, which are specific requirements. So basically, it's for a single family home, the landlord had lived there previously and then wants to rent out the unit for at a maximum 12 months. All right, so next one. All right, so now we're going to talk about a little bit of the applicability of the rent ordinance. So which properties are covered by the rent ordinance? So first you have fully covered units, which are called controlled rental units. They have rent control and just cause for eviction protection. So they're both covered with everything. So this is basically any multi-unit property built on or before February 1, 1995. So in most cases, you're going to be looking at apartment buildings. All right, the next category is partially covered. So this means that only the just cause for eviction protections apply, but there is no rent regulation. There's no rent control for these types of units. So this would be subsidized units, including Section 8, because their rent is regulated by the Housing Authority. Properties with one dwelling unit on one parcel, that would be, for example, a single family home. Also condominiums are in the same vein, and then also new construction, which is anything constructed or had a certificate of occupancy after February 1, 1995. And there it says that, so Costa-Hawkins, the little asterisk, says Costa-Hawkins requires units be permitted with a certificate of occupancy in order for it to be, constructed on that date. All right. So the last category is fully exempt. So this means that although they are in Richmond, there is no rent regulation and there's no just cause for eviction protection for that tenancy. So some examples of this, and these are much less, but this would be like where a landlord and a tenant share a kitchen or a bathroom. All right, so basically if they live together, then that unit's going to be exempt. Single family homes where a permitted ADU, which is an accessory dwelling unit, was added and the main house is owner occupied. So remember though, that ADU has to be permitted in order for it to get this designation. Another example is retirement homes. Okay, So now we're getting to the petition aspect and just kind of these overarching questions. So who can file a rent adjustment petition? And specifically, since this workshop is focused on rent decrease petitions, this one's going to focus on tenants. So any tenant in occupancy of a fully covered unit, which means the rent control and just cause for evictions protections apply, may file a rent adjustment petition. Tenants may file the petition themselves or have a representative file it for them. Tenants in different units may file based on a shared or similar issue, but each unit must file their own petition. The hearing examiner has the ability to consolidate multiple petitions if he believes it's in the best interest of the agency and the overall, just to save time and effort. But still, it is required that each unit file their own petition. Tenancies not under rent control may not file a rent adjustment petition. These are usually properties that we just discussed that are only under just cause for eviction protection, such as single family homes, one dwelling unit on the property, condominiums, or rental subsidized by the government, such as Section 8 or tax credit units. So again, those units may not file a rent adjustment petition because they're not rent controlled. Because they're not rent controlled, our agency has no authority to regulate the rent. Okay. All right. So this is the first kind of type of petition that we'll be discussing, which is petitions due to excess rent or too much rent. They're just overcharging. So petitions for excess rent may be filed due to failure on behalf of the landlord or master tenant to roll back the rent to the base rent for charging rent above the maximum allowable rent. So the rollback was required as part of the ordinance. Basically, when we started, part of the law was, that landlords had to roll back the rent to what it was in 2015, July 2015. And if they didn't, and they continued to charge above that, then a tenant has a right to file a petition and challenge that rent. Another reason, the MAR is calculated by taking the base rent and adding applicable annual adjustments. If applicable, the MAR will also include any approved upward or downward rent adjustments granted through the petition process. So again, this is just explaining how the MAR is calculated. And again, the starting base rent for rent controlled units is the rent paid on July 21st, 2015. Remember, that's if the tenancy was in existence prior to that date, or the rent amount paid on the first month if the tenancy started after July 21, 2015. Excess rent petitions may also be filed by subtenants who are overcharged by a master tenant based on the proportion of space and services shared. So again, I think I just want to make that clear. Subtenants and tenants have the same rights to file petitions for overcharges. Okay, the next one is petitions for excess rent due to overcharges, but specifically in regards to security deposits. So failure to return a security deposit is considered a rent overcharge because the security deposit is considered rent. A tenant may file a rent adjustment petition for excess rent if the tenant believes they paid too much in rent in excess of the MAR, including the landlord's refusal to return the security deposit. So it's not just, since we see a deposit as rent, if they fail to give it back to you pursuant to state law, then that could be considered an overcharge and you can file a petition. Important petition tips, that's on the bottom. It says have a record of receipts of paid rent from when your tenancy started. The rent adjustment petition requires copies of your lease, rental agreement, notices of rent increases, canceled checks, rent receipts, building inspection reports, or other evidence to support your claim for overcharges. I mean, the best way to think about this is it's similar to a lawsuit. Similar, but not the same. We definitely are not a court, but there is a presentation of evidence, there is cross-examination, there is closing arguments, and so there are some similarities there, and I'll go over this in a little bit as well. All right, so tenant attachment example A. This is an example. This is exactly what the petition looks like when you download it or see it in person. So this one is specific to tenant attachment A. So this is, again, for excess rent due to overcharges or failure to refund security deposit. And this can be found, it's available on our website at that address. And note, this is not the only part of what you need to submit, and I'll go over this in a second, but tenants also must submit the general tenant petition packet in addition to attachment A. Every tenant who files a petition must file the tenant petition packet. And then based on whatever issue you have, you'll choose the attachment. Now for this one, attachment A, remember, it's overcharges, or just straight up overcharges, or failure to refund a security deposit. And as you can see, you can pick the box, which one you are alleging. You enter in some of your basic information, the address, you know, what date you first start to rent the unit, what was the monthly rent, did you pay a deposit, how much, and then there's space to allow the petitioner to write down, well, when were the rent increases? What were the dates of those rent increases? Which goes back to the previous point of, like, you know, it's important to keep track of, you know, how much you pay, how you paid it, when you got a rent increase notice. Just keep everything. I mean, that's just basic landlord-tenant kind of advice. And then there's other information about the AGAs there. And so, and by the way, these petitions need to be completed, or else we will send them back and say, you didn't fill out this or that, and so you need to redo it. All right, petitions due to a reduction in space, services, and habitability. So this is a different attachment. So this is excess rent based on overpayment due to conditions of the rental unit. So you may file attachment B, not A, we're talking about B now, tenant petition if your landlord has, 1, taken away some of your living space or the benefits of your rental agreement, otherwise known as housing services. The amount of the rent decrease will depend on the amount of space or housing services taken away and how long ago it was taken. The hearing examiner will take into consideration past decreases as well as the replacement cost of the space or service in question. 2, if the landlord has provided inadequate housing services or ignored that the rental unit needs substantial repair. Substantial deterioration means a noticeable decline in the physical quality of the rental unit resulting from a failure to perform reasonable or timely maintenance. Remember that that's key. The reasonable and timely maintenance is key. It's not, you know, it's not a strict liability, kind of like if they kind of take a few days to get to something, it's not necessarily a violation. Remember, there's a criteria here, and that it has to be reasonable or timely maintenance. The landlord has, also if the landlord has failed to make reasonable repairs at all, which is noticeable, and the housing services no longer allow the tenants to live in a clean, safe, and sanitary rental unit. The amount of the rent decrease shall be based on a determination of the inability of the tenants to enjoy the rental unit due to its poor condition. All right, the third one is for code violations and poor living conditions. This is probably more common, I think, at least, you know, as a counselor, I talk to many people, and a lot of the issues come from this kind of basis. So where the condition of the rental unit threatens the health or safety of the people living there, the rent may be reduced in an amount that reflects the reduced value of the rental unit due to the unsafe or unhealthy condition. The defective conditions of the rental unit rise to the level of a violation of the guarantee of a clean, safe, and sanitary place to live. And let me just interject something right there. The guarantee that we're discussing is based on some law. So there's the implied warranty of habitability, and there's also some California statutes that require certain minimum standards for human habitation whenever there's a residential rental. That's what we're talking about. So in that situation, the rent shall be decreased no less than 10% for certain defects and no less than 20% for more significant defects until the problem with the rental unit are corrected. So until those problems are corrected, this rent reduction may continue, and that's how a decision may be written. The rent decrease that is approved will be doubled if the landlord fails to correct the issues at the rent unit, and if proof of repair is not submitted to the rent program within 35 calendar days of mailing of the hearing examiner's decision, unless the landlord establishes that the violation cannot be corrected within that time due to circumstances beyond the landlord's control. I think that's more prevalent these days because of the pandemic. It's more difficult for landlords to hire contractors and even enter into a tenant's unit. There's always complications. So, we're kind of seeing some of that now, but that's, largely due to the circumstances of the pandemic. During this time, no rent shall be charged for a period in which the landlord is found to be in violation of California Civil Code Section 1924.4 for pursuing an eviction when there are code violations that have not been repaired. If the rental unit needs repairs for conditions that affect health and safety, the landlord has broken their obligation to the tenant. Temporary relocation may be appropriate. So again, this goes back to the implied warranty of habitability. And this implied warranty of habitability is an implied promise that comes with every California residential lease. And therefore, if the landlord has in fact failed their duty to provide habitable premises, then they have actually broken the lease, and then the tenant has also potentially been overcharged because, right, it's supposed to be a meeting of the minds. It's supposed to be an equal exchange. 100% of the rent that the tenant is required to pay, they pay 100% of what the landlord is asking, and in exchange, the landlord provides 100% habitable unit. But if they're off somehow, then the rent has to be adjusted. All right, so here's an example of attachment B. So again, this is excess rent due to a reduction in space, services, and habitability. It's on our webpage. And remember that tenants must also submit the general tenant petition packet in addition to attachment B. It's very important you to remember that. So at the top, you can see there are the grounds for filing a petition, and it can vary, right? So the first one is taking away some of the living space or benefits of the rental agreement. Second one is the landlord, and again, it can be against the master tenant. Landlord or master tenant has provided inadequate housing services. Landlord or master tenant has ignored that the rent unit needs substantial repair, or the landlord has code violations and poor living conditions. Then there's some space for the basic unit information. Then there's a section for to jot down if there has been an inspection on the unit recently. And also the last part, and then there's additional pages to follow where if you need more space, but that's where you can actually list the problematic conditions of the unit. So we understand, and it's important to give that as much detail as possible so that the hearing examiner can really understand, the depth of these issues. And what you may think is minor may not be. So please make sure to write down as much as possible every detail of a problem that you see. All right, the next one is a petition due to the landlord's failure to pay relocation payments. So this is only in the context of when relocation payments are required by law, by the Richmond's relocation ordinance. So the city of Richmond requires landlords of rental units in the city of Richmond to pay relocation payments to mitigate the challenges faced by tenants who are ordered to vacate a rental unit through no fault of the tenant. These payments, although required by the rent ordinance, are governed by the city of Richmond's relocation ordinance. Again, that's the city of Richmond's relocation ordinance. It's not the rent programs ordinance, but still we are dealing with it a lot. So that's why it's part of our presentation. So there's two types. One is going to be permanent relocation payment. So this means that the per unit payment this is the per unit payment required to be paid by any landlord on a pro rata share to an eligible tenant or tenants, who takes action to terminate tenancy based on either one, owner move-in, withdrawal from the rental market or LSAC, or due to a government agency's order for the tenant to vacate the rental unit or due to other conditions. And then the second type is temporary relocation payments. So again, these are not permanent, these are almost like a per diem. This means the payment required to be paid to the tenant by any landlord who takes action to terminate tenancy in order to undertake substantial repairs, which is a just cause for eviction. But again, that's a temporary, well, it can start as a temporary one and become permanent, but usually it'll start as temporary. Or two, when the tenant has temporarily vacated a rental unit in compliance with a governmental agency's order to vacate, or due to health or safety conditions, and for which no notice to terminate tenancy was served. So again, sometimes the government, like the city, can, quote unquote, red tag unit, or there's, just substantial health and safety conditions. And in those situations, it's actually not the landlord who's saying you have to leave. It might be someone else. And even in that situation, though, the landlord may be responsible to pay these temporary relocation payments while the work is being done. If the necessary repairs have not been completed after 60 days or more when the tenant vacated the rental unit voluntarily, the tenant may be entitled to a rent differential payment, and possibly after 120 days, a permanent relocation payment as well. So this is in a situation where things are taking months to fix, but it's pretty rare to see, to be honest. I don't think we've seen that too much, but it is possible as it's part of this law. All right, filing the petition. To obtain a determination that a relocation payment is owed, the tenant must mail or bring the following items to the Richmond Rent Program. And we'll discuss this a little bit more as well. One, a completed petition signed by one or more tenants or subtenants. Two, a copy of any supporting documentation. And three, a proof of service stating that the opposing party, the landlord or landlord's representative, was served a copy of the petition and any supporting documentation either by first-class mail or in person. Failure to serve a copy of the petition on the opposing parties may delay resolution of the petition. And then on the bottom, there's a small note. It says temporary relocation payments, in addition to possible rent differential payments, are determined by the tenant's willingness to temporarily vacate, the continued payment of rent, and the number of days after the landlord's notice that the repairs take. Not every tenant is entitled to relocation payments. So again, a key component of this is the continued payment of rent. That's a key component to get these payments. All right, so now we're going to discuss, just basics on how to actually file a petition, regardless of what type of petition it is. So steps to filing the petition. This is the overview. So under the Fair Rent, Just Cause for Eviction, and Homeowner Protection Ordinance, rents are adjusted through an annual general adjustment, which is the cost of living increase or inflation, and through individual rent adjustments, increases or decreases in rent through a petition process. Tenants living in a rent-controlled unit may file a downward rent adjustment or rent reduction petition pursuant to Rent Board rent adjustment regulations. A Rent Board hearing examiner, who is similar to our judge, but they're kind of like what's called an administrative law judge, may order a rent reduction and or a retroactive rent refund in cases where a tenant has experienced a decrease in space, services, habitability, which are living conditions, or a decrease in the number of tenants allowed in the rental unit. So let me quickly explain that. The difference between a rent reduction and a retroactive rent refund is retroactive rent refund means something has happened in the past, and therefore the tenant is entitled to get a refund for rent he or she has already paid. Whereas a rent reduction is moving forward, and they could in theory get both, but that's the difference. It's one is in the past and one is in the future. All right. So step one, This is an important and crucial step that I think a lot of people don't take advantage of enough. And we highly encourage you to do this, which is contact the rent program and speak to a services analyst to discuss your case and learn about your rights under the rent ordinance and rent regulations. Tenants should consult with a rent program services analyst by calling 510-234-7368 prior to filing a petition to ensure correct filing and to understand how the rent adjustment petition process works. Rent program services analysts are available Monday through Friday, 9 a.m. to 12 p.m. and 1 p.m. to 4 p.m. I supervise the public information unit, so in many cases, you may be talking to me as well. And I can definitely discuss any questions you may have, but neither myself nor anybody or the analysts may give legal advice, but we can inform you as to what options you may have under the rent ordinance. All right, step 2. Complete the form called Tenant Petitions Multiple Grounds. This is the one that I was saying earlier, the tenant petition packet. That's the one. It's very important. You got to fill this general petition first, and then in addition, the attachment that applies. So this petition must be completed and filed to be deemed complete. This form can be downloaded at the website there on the screen. And on the website, this form is titled Tenant Petition Packet. All right, step 3, complete the appropriate attachment. So again, just as you have to do the tenant petition packet, you also have to make sure you put in a specific attachment for which issue you're claiming you are entitled to a rent adjustment. So tenants can petition for multiple grounds at the same time. You don't have to just do attachment A or attachment B. Sometimes you have both excessive rent and there's substantial deterioration of the unit. So you would file attachment A and attachment B. So those ones are listed at the bottom there. So step 4, make sure to include your documentation or evidence to support the rent reduction claim. When filing a petition, tenants should submit complaint letters, emails, texts, photos, videos, inspection reports, and any other documentation to support the grounds for the rent reduction. Remember that the hearing examiner's rent adjustment decision is based on a preponderance of the evidence, which is basically 51%. Again, this is extremely important. The evidence is going to make or break your case. It's super important, and anybody who is considering filing a petition to document your issues, whether that be you sending an email to the landlord saying, there's this issue, so can you come and take a look, or can you come fix it? Or any notices you receive from the landlord. There's all kinds of stuff. Basically, the evidentiary rules in our hearings are very open. We don't, have the same kind of evidentiary rules in court. It's basically anything that you wish to present, you can. But you have to send that evidence to the other side as well, in addition to the petition, a copy of your petition to the other side. Basically, there's no surprises. Everybody gets a copy of everything else. All right, step 5. Complete and submit a proof of service to the rent program and all parties. An important part of the petition process is the requirement that a tenant must complete and submit a proof of service along with the completed petition packet, which includes forms, attachments, and documentation. When submitting a proof of service, the tenant is declaring under penalty of perjury that they will serve a copy of the petition, or have served a copy of the petition that was submitted to the rent program to the other party, or the landlord, or sometimes the master tenant. So the proof of service is just saying, I am declaring that I gave a copy of this petition to the landlord on this date, signed, dated. And we can't proceed without that. So again, it's the petition, the tenant petition packet, whichever attachment you are alleging, your evidence, and then the proof of service. All of them put together. That's a completed packet. Now, when you have that completed packet, you must file the original copy by using one of the following methods, by mail. Obviously, we're still not open to the public, so in terms of in-person, so you can do it by mail or by email. The address is City of Richmond Rent Program Attention Hearings Unit, and that's at 440 Civic Center Plaza, Suite 200, Richmond, California, 94804. Or what may be easier and faster is you send it by email to rent@ci.richmond.ca.us and put in the subject line Attention Hearings Unit. All right, so now we're just going to go overview of the process itself. So this is after you've submitted the petition to our office. So upon receipt of the petition, rent program staff members will review the allegations in the petition to determine if the petition is complete. A petition may be deemed incomplete or unacceptable within 5 days of it being filed. If the petition is not promptly corrected, the file may be closed. And we will notify you if it is complete and give you that time to correct it. Once accepted as complete, the landlord will be sent a notice of right to object to the petition, which will be due within 21 calendar days of the mailing of the notice. So again, the landlord, if you're a tenant, you file a petition, your landlord, if you file it against the landlord, or the master tenant, if you file it against the master tenant, has a right to object. And they have these 21 days to file their objection. And if they do, then we'll set it up for a hearing. So a settlement conference and hearing notice that will include the time, date, and place of hearing and information about the hearing process will be mailed to all parties no later than 10 days before the scheduled hearing date. So no matter what, everybody's going to receive the information at least 10 days ahead of the hearing so that you can adequately prepare. Continuances of a hearing date, which means you want to push the date later, must be requested in writing no less than 48 hours prior to the hearing. So if you try to request a continuance the day before the hearing, it's not going to be granted, most likely. After a decision is made, the decision can be appealed by the tenant or landlord within 30 days or 35 days if mailed of the decision, and no less than 14 days prior to the next rent board action meeting. All right, so this is the day of the hearing. This is kind of what to expect when you actually sit down, well, not sit down, but I guess get on the phone or get on Zoom with a hearing examiner. You know, in the future, obviously, we may be resuming in-person hearings, but for now, we still have to do it remotely. So before the hearing starts, each party must introduce themselves for the record. The hearing examiner may not discuss the case unless all parties are present. The settlement conference and hearing can only proceed if all parties are participating, unless there's a complete failure to appear by the responding party, in which case the hearing can still go forward. So basically, if there's just a no-show by the landlord, they'll probably still move forward. A failure to appear by the petitioning party will generally result in a dismissal of the petition. So the petitioning party here in these kinds of petitions would be the tenant. So if you file a petition, but you fail to show up to the hearing, your case is going to be dismissed, most likely. All right, part 2, settlement. Each petition and corresponding objections present openings for possible settlement motivation. So a settlement is just a way for parties to come to a resolution without the hearing examiner really issuing a decision. They don't rule on it. It's just between the parties, and hopefully you can actually work things out. And the hearing examiner tries to emphasize that. But if that can't work, then he'll go back to the hearing. But the advantage of having a settlement is that you can actually incorporate issues that were not necessarily alleged in the petition itself. It can actually kind of be a global settlement, which is helpful. All right, so part 3, evidence. The parties may have submitted evidence with their petition or objection. Any other documentation, such as invoices, photographs, text messages, to be reviewed during the hearing in the form of exhibits, which is a document designated to support or contest a specific claim, must be provided electronically to the rent program and all parties no less than 2 business days before the hearing. So again, 2 business days, you have to submit it. And again, like I said, the evidentiary rules in these hearings are very relaxed. Basically, you can bring in anything that you want. There's no, or not the same high standard evidentiary rules as you would see in court. So basically, if you have some type of evidence, there's no harm in bringing it. You know, whether or not the hearing examiner uses it to base his decision on is up to him, but still, it's good to present as much as possible. All right, part 4, cross-examination. So the hearing examiner will ask questions to the parties present about their pre-filed testimony or evidence to better understand the party's position in the case, or to ask questions to challenge their credibility or accuracy. Further, and it doesn't really say this here, but you know, parties can cross-examine each other. So at some point, the hearing examiner will ask one party to, you know, testify about one thing or the other. But then at another time, the hearing examiner may allow the other party to say, well, you can cross-examine what they just said. But again, this is all kind of up to the hearing examiner. Part 5, rebuttal. To the hearing examiner's discretion, each party may have an opportunity to contradict evidence presented by the other party. So you may present evidence, text, photos, documents, etc., in rebuttal to disprove or rebut new evidence presented by the other side. So again, this is where, you know, one side presents their evidence, and then you could say, well, that is not true because I have an email that says this or something like that, right? And again, this is all kind of directed by the hearing examiner. They are the ones, he is the one in charge, and they're the ones to kind of direct how this hearing will go. And so it's not like you have to remember all of this. This is just to kind of give you a basic overview and what to expect on the day of the hearing. Part 6, closing arguments. The hearing examiner will close the hearing and or decide to keep the case open for further analysis to later make a decision. A written decision will be sent to all parties after the hearing pursuant to Richmond Rent Board Regulation 837. The decision is likely to be sent between a few weeks and a few months after the hearing. So again, you know, each party has their ability to kind of wrap up their case, provide it to the hearing examiner, and then they will make a decision later at some point based on the evidence submitted and the testimony presented during the hearing. All right, so this is the last slide, by the way. After a petition is completed, filing an appeal. So this is a process that is, you know, still available to both landlords and tenants in their respective petitions. Any party may appeal the decision of the rent program hearing examiner. Such appeal must be filed no later than 35 calendar days after the date of mailing of the hearing examiner's decision. On appeal, the board, and again, this is the rent board, it goes from the hearing examiner to the actual 5-panel rent board. On appeal, the board shall affirm, reverse, or modify the decision of the hearing examiner. The filing of a timely appeal will stay, which means put on hold, only that portion of the decision that permits payment, refund, offsetting, or adding rent. And that's pursuant to Richmond Rent Board Regulation Section 842B. If you're filing a late appeal, you must state the reason in writing as to why it's late, and include it with your appeal so that the rent board can determine if there is good cause for the untimely filing. The filing of an untimely appeal does not stay any portion of the hearing examiner's decision. If the appeal is timely filed, the rent program will provide information required to appear or listen in on the rent board meeting where the appeal will be heard. And then finally, any person who wishes to appeal the rent board's decision, okay, so again, this is an appeal of the rent board's decision. So basically, this is an appeal of an appeal, may seek judicial review by filing what's called a writ of administrative mandamus with the superior court within the jurisdiction. So again, overview, you file a petition, the decision doesn't come out in your favor, you can appeal it to the rent program. Then if that decision is still not in your favor and you still want to appeal the decision, you would then have to file this writ in the superior court in Contra Costa County. All right. I want to thank everybody for joining us today. Hopefully you got some great information about our petition process. We will have some time for a Q&A. And as always, if you have questions about any of this, or in the future you're going to file a petition, feel free to call us at 510-234-7368 or email us at rent@ci.richmond.ca.us. Thank you.
Thanks, Palomar. So we don't have any Q&A questions submitted yet. I want to encourage any participant to enter a question into the Q&A box, and we'd be happy to address that. We'll give folks a couple minutes to think about their questions. So seeing as there are no questions, I think we can commence this morning's presentation. I want to thank everyone for joining us. And if you do think of questions after this presentation, as Palomar mentioned, feel free to give us a call or send us an email, and we'd be happy to assist you. Thanks.
Thank you, everybody. Take care.